Good afternoon or good morning to all of you who are joining us for this webinar. It's a pleasure to welcome all of you. My name is Margie McHugh, and I'm the Director of the Migration Policy Institute's National Center on Immigrant Integration Policy, and I'll be moderating today's webinar titled Chilling Effects, the Expected Public Charge Rule and its Impact on Immigrant Families. Before we get going, I just want to go through a few housekeeping issues. You'll see up here on the screen, it'll be fairly easy, I think, for you to find slides and audio for the webinar after it ends up on our website, migrationpolicy.org/events. And if you have any problems accessing the webinar or the slides, please just send us an email at events@migrationpolicy.org, or give us a call at 202-266-1906. We have folks standing by ready to help out if you have any difficulties. Third, we really appreciate it when we get questions during the webinar. That lets us sort of tee up, combine questions where we need to, et cetera, et cetera. So super helpful for us if you send your questions throughout the webinar. And again, you can send them in either through the actual webinar platform or send them to us at events@migrationpolicy.org. So just quickly, I'll do, I guess I would say, real introductions before each of them speaks, but you'll be hearing today from Michael Fix, who's a senior fellow and former president here at Migration Policy Institute. Mark Greenberg, who we are thrilled decided to join us as a senior fellow after he left his service in the federal government last year, and also Zhana Batalova, who's a senior policy analyst and manager of MPI's Migration Data Hub. All three of them are co-authors of the report that we're releasing today. So in terms of the report, you can see it up there you can see a snapshot of it up there on the screen. I'd expect that all of you are aware that the Trump administration is preparing to make major changes to policies governing the use of public benefits by immigrants and their dependents, and that as a result, fears regarding the consequences for using benefits are already running very high in communities around the country. So today's report release, Chilling Effects, the Expected Public Charge Rule and its Impact on Legal Immigrant Families' Public Benefits Use, provides both an analysis of potential impacts of a new rule using data on the current use of benefits of major public benefit programs by immigrants, and it also provides an analysis of the history of public charge policy and the proposed changes. So to walk us through the overall context of the report and some of that information, first you're going to hear from Michael Fix, who needs no introduction for those of you who have been following MPI's work over the years. Michael joined MPI in 2005 as the Vice President and Director of Studies, and subsequently served in numerous roles here, including as President and CEO. Both in his time as the Director of Immigration Studies at the Urban Institute and also here at MPI, Michael has always had a keen interest in issues affecting immigrant and refugee children and families, and in particular in the effects of federal welfare reform policies on immigrants. So obviously there's a very clear line from his body of work over the years to a great concern over the potential impacts of changes in the public charge rule. So it's a pleasure to hand the baton first to him so that you can hear more about the basic framework of the report and some of the analysis.
Thank you so much, Margie, and many thanks to all of you on this webinar. As Margie said, I'm a senior fellow here, but I'm perhaps proudest of the fact that 10 years or so ago, Margie and I co-founded the National Center on Immigrant Integration Policy, which has just proven to be such a very important instrumentality in MPI. I'm going to start by just saying a few words about how we're going to proceed in talking about our newly released report on impacts of impending changes of the current public charge rule. As you'll hear, and as Margie noted, the rule is going to expand the factors that would be considered in determining whether a would-be immigrant could be determined to be a public charge, historically considered someone who is dependent on public benefits. In a nutshell, the proposed rule could lead to a sharp shift in immigrants' use of public benefits as participation falls because of fear or confusion or the rule's chilling effects. And we also worry that the rule could serve as a kind of backdoor reform to legal immigration in the United States. So after I make my short introduction, MPI Senior Fellow Mark Greenberg is going to discuss the evolution of the rule, walk us through key elements of the proposed draft rule, and the policy changes that it represents. Then Zhanna Batalova, our Senior Policy Analyst and Demographer, will discuss our report's analysis of benefits use of immigrants and their families and the chilling effects that may flow from proposed changes. Then I'll conclude our presentation here by summing up and saying a few words about the leaked proposed rules, broader policy implications, and then turn the program back to Margie McHugh, who will moderate the question and answer. Now, I would say that the proposed rule hasn't exactly been ignored by the policy and service communities, and there has been, and I think will be, much good analysis of it that will be carried out. But I just want to call your attention here to some of what we believe to be some of the distinguishing features of our report. First, it draws on the lessons of the 1996 welfare reform law and its aftermath, most notably the sharp declines in immigrants' use of public benefits that followed, and that provide, we think, something of a guide to what might flow from the adoption of the draft proposed rule. Second, we provide a legal and a historical analysis of the public charge regulation that goes back fully a century and has been addressed in 3 separate official and unofficial Trump administration documents. A third defining feature of our report has been our effort to estimate the number and characteristics of immigrants whose use of benefits could factor in a public charge determination and how those numbers differ from those under current regulations. We do this by using the Census Bureau's American Community Survey to calculate the participation in 4 major means-tested federal benefits programs. We examined 2 cash benefit programs, TANF and GA is one, and SSI is the other, and we examined 2 non-cash benefit programs, SNAP or food stamps, and Medicaid and the Child Health Insurance Program. Although they're not included in the ACS, we've also developed a proxy for analyzing the numbers and characteristics of immigrants who are potentially eligible for subsidies under the Affordable Care Act. The groups we examine are non-citizens, naturalized citizens, and the U.S.-born. Because the rule extends not just to benefits used by individuals, but their dependents, we break out use by individuals and by individuals in families. Zhanna will decode that. We also break out benefits used by children, including citizen children of immigrants, as their use will likely be covered by the new rules. And we break out Hispanics and Asian American Pacific Islanders, the 2 largest immigrant groups in the United States. Finally, we provide estimates for the U.S. as a whole, and here is probably the most important thing I will say. We break them out by state, and those state profiles can be accessed at bit.ly/, one word, public charge state data. Let me say that again, bit.ly/ public charge state data. All right. Now, before I turn the program back to Margie, let me just say a few words about a key element of this report, what we refer to as the chilling effects of the leaked draft proposed rule. Now, the notion of chilling effects is nested in a set of studies that were conducted in the wake of the 1996 welfare reform law, some of which I am old enough to have participated in and which are summarized in a 2009 Russell Sage Foundation volume that I edited on welfare reform and immigration. We've defined chilling effects as the benefits and services that immigrants and their otherwise eligible family members forego out of either fear or confusion. Now, what did those studies find? Following welfare reform, there were steep declines in participation by differing groups in different programs, declines that ranged from 20 to 60%. We also saw declines in benefits use at that time among populations that were exempted and that were protected from the laws, specifically refugees, immigrants who were in the United States for 5 years or more, who were outside the restraints of the bars that were introduced by welfare reform. And we also saw declines among U.S. citizen children with foreign-born parents. Jana later on will quantify these effects, and for now, I'll turn the floor back to Margie McHugh.
Great, thank you, Michael. So it's a pleasure now to introduce Mark Greenberg, who joined the Migration Policy Institute almost exactly a year ago, just a few weeks short of that, as a senior fellow, and his work here focuses on the intersections of migration policy with human services and social welfare policies. Mark has a long history of working in the anti-poverty law and policy field, but most recently served for 8 years in senior leadership positions of the U.S. Department of Health and Human Services Administration for Children, Youth, and Families, and most recently there served as Acting Assistant Secretary from 2013 to 2017. With a budget of more than $50 billion and roughly 60 major health and human services programs under its jurisdiction, Mark's work there caused him to be deeply involved with federal policy and research related to refugee resettlement, unaccompanied children, and major human services programs such as TANF, Head Start, child care, and child support. So needless to say, he brings uniquely deep and well-informed perspective, both as an author of the report and to the particular issues we'll be discussing today. So Mark, great to be able to turn the webinar over to you now.
Thank you, Margie, for that kind introduction, and good morning, good afternoon, everybody. We greatly appreciate having the opportunity to talk about the report and the findings in the report. For the next 10 minutes, I'm going to be talking about how public charge is part of immigration law, say a very brief bit about history, discuss the current standards, and then discuss what we know about the administration's plan to change it. To begin, the concept of public charge has been part of U.S. immigration law since 1882. And broadly, current law says that an individual shouldn't be admitted to the United States or get adjustment of status, that is, get a green card, if he or she is or is likely to become a public charge. There's then a separate provision of law that says that individuals can be deported on the basis of public charge, and importantly, public charge does not apply at all to naturalization. The law itself doesn't actually define public charge, and there have been varying standards over its history. But since 1999, under guidelines issued by the Immigration and Naturalization Service in that year, public charge has had a very clear meaning. For purposes of admission and adjustment of status, a public charge is an individual who is primarily dependent on cash assistance for income maintenance or institutionalization for long-term care at government expense. The law says that in making the determination that officials should look at a set of factors to determine the likelihood of someone being a public charge, look at age and health and family status and assets, resources and financial status, education and skills, can also be a consideration of the sponsor's affidavit of support. So notably under this standard, the focus is on cash assistance or long-term institutionalization. As a result, non-cash assistance like SNAP benefits, food stamps, housing assistance, energy assistance don't count. Healthcare benefits other than institutionalization for long-term care doesn't count. And the focus isn't on any receipt, but rather on primary dependence. The focus is also on the individual, not on the individual's dependence. Under the 1999 guidelines, there's a much narrower test for deportation. In addition to looking at cash assistance and long-term institutionalization, the individual must also owe a debt for services received, and the individual or sponsor must fail to pay after all available actions to collect have been made. So that's the standard that has applied since 1999. The reason that we're here today and we've written this paper is because the administration is planning to propose significant changes to the definition of public charge and how public charge is determined. As Michael noted, the administration's interest in doing so was signaled long ago, signaled in the first days of the president's term in a draft executive order that was never issued. Then last December, the Department of Homeland Security announced that it was developing a proposed rule concerning public charge. And in the December announcement, they projected a July 2018 date for the Department of Homeland Security to issue the proposed rule. Since that time, we've seen 2 leaked drafts of the proposed rule. And much of what we'll be talking about today is based on what that most recent leaked draft from March says. It's our understanding that the proposed rule is under review by the Office of Management and Budget. We don't know if the proposed rule is going to be released in July or at another time. And when the proposed rule comes out, it may or may not be very different from the drafts that were leaked. When the proposed rule does come out, there will be a public comment period. The agency has got a legal responsibility to consider public comments submitted during the period before it issues a final rule, and at least in the leaked draft, they had envisioned a 60-day comment period. So we know the administration's planning to take actions. We know what was being considered in March. We don't know exactly what they'll put forward, but when they do put it forward, there'll be opportunities to weigh in. From the draft proposed rule, there is reason to expect that public charge standards would change very dramatically under the rule that would be issued, principally by broadening which public benefits count in a public charge determination. And in the leaked draft from March, it says that someone would be inadmissible on the grounds of public charge if they are likely at any time to use or receive one or more public benefits. It then has a definition of public benefits and says public benefits means any government cash or non-cash assistance or services that's means tested or intended to help individuals meet basic living requirements such as housing, food, utilities, or medical care. And under this definition, it would include every form of cash or non-cash government assistance in the form of aid or benefits or services unless it is expressly excluded. And that includes a number of benefits. I'm not going to read everything on the PowerPoint slide, but that will include SNAP benefits and Medicaid and children's health insurance, housing assistance, transportation assistance, low-income energy assistance, the refundable earned income tax credits, and others, because if it falls within that definition, it counts unless it's expressly excluded. It would also include federal, state, local, tribal, and territorial benefits. Under the proposed rule, they would count benefits received by the individual and by other dependents of the individual, and the other dependents of the individual would include the individual's children, including their citizens' children. And as noted, the focus is on receipt or likelihood of receiving benefits, so it's not asking primary dependents, it's asking do you receive or are you likely to receive. In doing this, they would apply this totality of circumstances test, looking at age and health and family status and assets, resources, financial status, education and skill. But what's really crucial to appreciate is that they're looking at this totality of circumstances test to determine if someone is likely to receive anything that falls within the rule definition of public benefits at some future point. The rule in its draft leaked form envisions that some factors would be heavily weighted either against or in favor of the applicant. Among the things that would be heavily weighted against the applicant is either current use of any of these benefits or use in the past 36 months. To get a heavily weighted positive effect, most notable one is having assets, resources, support of at least 250% of the federal poverty standard. And that's about $62,750 for a family of 4. So taken together, the provisions would allow the federal government very broad discretion to deny admission and adjustment of status for anyone who's receiving or has received in the last 36 months any of a broad range of public benefits, and also to deny admission or adjustment of status if the individual as a dependent has done so. For example, a citizen child who has received SNAP benefits or Medicaid or other subsidized health. The rule would apply to visas for admission based upon employment, family reunification, diversity. We think, for reasons that we discuss in the report, the greatest effects are likely to be not on the employment side, but in the family reunification and diversity side. The draft does say that it would not apply to certain groups. That includes refugees and asylees, survivors of trafficking, special immigrant juvenile, and some other groups that are listed in the draft rule. To say a word about deportation, it's not clear at this point whether the rule would have any effects on deportation standards. The reason it's not clear is in the March draft, there was a section called deportation, but it said criteria to be determined and for discussion with the Department of Justice. So at that point, they presumably hadn't made a decision. That does mean that when they come forward with the proposed rule, it could result in a change from current standards. It could result in no change from current standards. And if they made a current change from the standards, we don't know what that change would be. So finally, I just want to reiterate, all this is in a draft proposed rule. The proposed rule could come out any day, could be very similar to or substantially change from what's in the leaked draft. So it'll be important to review the proposed rule closely when it's issued. And now let me turn back to Margie.
Great. Thanks, Mark. And thanks to all of you who are sending in questions already. Please keep sending them in, and I'm pretty sure we'll have plenty of time to get to all of your questions. But for those of you who join us for webinars more regularly, you know that we also send follow-up responses to any we don't get to. So please keep them coming, either through the chat function or to events@migrationpolicy.org. So now you'll hear from Zhana Batalova, who's a senior policy analyst here at MPI and also the manager of our migration data hub, which is, I would say, the umbrella that goes sort of across MPI's what we call facts, stats, and maps, covering both U.S. and global data on immigration and immigrant integration. Because of her expertise in both data analysis and a wide range of immigration and integration policy issues, she's had a hand in many MPI research projects ranging from social and economic mobility of first and second generation youth and young adults to the policies and practices regulating immigration and integration of highly skilled workers and foreign students. So Zhana, over to you to go through the some of the kind of deeper data analysis that people can find in the report.
Thank you, Margie, and greetings from MPI, everyone. As a data researcher, I have to start with perhaps less exciting but important elements of how we did the analysis. We pulled 3 years, 2014, 15, and 16, of the American Community Survey, which is a large nationally representative survey of U.S. residents conducted annually by the U.S. Census Bureau. ACS provides information on whether respondents or their family members participated in 4 major federal means-tested cash and non-cash benefits that Michael mentioned: temporary assistance for needy families, TANF, and general assistance, supplemental security income, SSI, supplemental nutrition assistance program, SNAP, and Medicaid and Children's Health Insurance Program, CHIP. I'll use acronyms from now on. Each of these programs is on the list of the benefits that would count in a public charge determination. Our data also capture health insurance coverage trends following the implementation of the Affordable Care Act, ACA. And because tax credits under the ACA would count as public benefits under the leaked draft proposed rule, we also wanted to examine them. Unlike some other U.S. population surveys, our data, American Community Survey, has a large sample size that allows us to analyze data with confidence, not only for the U.S. overall, but also for states, countries of birth, and racial and ethnic groups. All important as we want to understand impacts on different populations and geographies. ACS has limitations, however, and because of them, our estimates may underestimate the extent of the proposed rule's impact. For instance, the survey does not collect data on housing subsidies, WIC, earned income tax credit, and set of other programs and tax credits offered at the national and state levels. So we conducted a sensitivity analysis to gauge how many people we are likely to miss by focusing only on the 4 major federal programs, TANF, SSI, SNAP, and Medicaid. We find that overall there is a significant overlap between immigrants in our 4 programs and immigrants covered by programs such as WIC, housing assistance, and energy assistance. However, there are some other programs, for instance, free and reduced price school meals, which actually may or may not be included in the final rule because it wasn't clear in the March draft. But these programs would cover people who do not participate in our 4 major programs. So taking into account the benefits use of these additional programs would expand the number of immigrants and their families that could be affected by the anticipated public charge rule. So with that in mind, let me go over the key findings from our report. More than 6.8 million non-citizens themselves as individuals received at least one of the 4 main means-tested benefits, but a far greater number, 10.3 million, live in families where someone, either the individuals themselves or their family members, including U.S.-born children, receive benefits. Additionally, 7.4 million naturalized citizens lived in benefit-receiving families. So combining these 2 groups, we will get 17.7 million immigrants who live in benefit-receiving families. And if persons potentially eligible for ACA subsidies are added, the number of immigrants in benefit-receiving families would increase by another 2.4 million, up from 17.7 million. What do these statistics actually mean? Let's look at the changes in the shares of people receiving benefits that could factor into public charge decisions under the current versus leaked proposed rules. Under the current public charge standard, individuals relying on cash benefits can be deemed a public charge. So the blue bar shows that 3% of non-citizens received either of the 2 cash benefits tracked in our data, 3% for non-citizens. In sharp contrast, the share of non-citizens who lived in families receiving either cash or non-cash benefits is much, much higher, 47%. So the bottom line is that nearly half of all non-citizens in the U.S. could be affected by proposed Trump administration public charge rule, up from current 3%. This jump in shares is driven by 2 main factors: the use of benefits by family members, and the second, the expansion of benefits to non-cash programs such as Medicaid and SNAP that make up the bulk of benefits used by both immigrant and U.S.-born families. Additionally, if the rule makes benefits use grounds for deportation of legally present non-citizens, the size of the population at risk of removal could increase significantly beyond the current unauthorized and otherwise removable non-citizen populations. Let me say one word about the potential impact on the U.S. born. The proposed rule aims to limit the use of benefits among immigrants, so the U.S. born are not the primary target per se. However, there are some situations in which the U.S. born population could be affected. Let's take an example. U.S. born adults who wish to bring a spouse from abroad on an immigrant visa. If these U.S. born sponsors use benefits themselves or have family members who are dependents on the person seeking admission, and they use benefits, these U.S. born sponsors may have difficulties to reunite with their foreign born spouses. Another situation will involve U.S. born children in immigrant families. So if immigrant parents decide to leave public benefit programs out of fear for immigration consequences, or because they're confused about who is eligible now for which program, the U.S. born children will lose benefits too. We estimate that 10.5 million children under 18 resided in immigrant families that received benefits. Of them, majority, or 9.2 million, were U.S. citizens by birth with at least one immigrant parent. So the exact magnitude of the chilling effects of the proposed public charge rule is difficult to gauge. We estimated that about 17.7 million immigrants plus 9.2 million U.S.-born children reside in immigrant families that receive TANF, SSI, SNAP, or Medicaid. However, not all 27 million adults and children in immigrant benefit-receiving families are expected to withdraw from public benefits. And multiple factors could influence family decision-making, including need for public support, legal advice, understanding, or simply ignorance of the proposed policy changes, as well as the strength of local economies and labor market opportunities. Some of the best indications of how many people may alter their behavior in response to the proposed change in public charge policy come from studies conducted following the welfare reform. As Michael pointed out, those studies found sharp declines in participation levels that range from 20 to 60% across different immigrant populations and benefit programs. People left out of fear and confusion. If we use the lower bound estimate of 20%, the result would be that approximately 5.4 million immigrants and their U.S.-born children may leave the programs under the new rule. But if immigrants drop out at a higher rate of 60%, as many as 16.2 million may choose to forego these benefits. One goal of the proposed policy changes is to encourage self-sufficiency and discourage immigrant families from receiving any public benefits and instead to get a job. What we find that the share of working-age immigrants in families using means-tested benefits who are employed is high. Indeed, it's higher than the share of the U.S.-born counterparts. We find that 63% of non-citizens and 66% of naturalized citizens between ages 16 to 64 were employed, compared to 51% among similar U.S.-born working-age adults. And these high levels of employment indicate that most immigrants use benefits as work support. The impact of proposed rule will be felt broadly across the racial and ethnic groups. And in the report, we examined two largest racial and ethnic groups among immigrants, Hispanics and Asian Americans and Pacific Islanders. We find that about 3.8 million AAPI and 10.3 million Hispanic immigrants lived in benefit-receiving families. Like immigrants overall, the majority of working-age AAPI and Hispanic immigrants in benefit-receiving families were employed and using benefits as work support. The chilling effects The chilling effects of the proposed rule will likely be greatest in major immigrant-receiving states, as well as states that have extended public benefits to non-citizens and their families beyond what is provided by the federal government. California and New York the very first two states on the left are examples of both. This figure shows the top 25 states with the largest number of immigrants in benefit-receiving families. California and New York together account for 41% of the nation's 18 million immigrants in benefit-receiving families. Texas and Florida, the two states with the next largest numbers, were home to 20% of such immigrants. Altogether, the top 25 states accounted for 94% of immigrants living in families that receive at least one of the major four benefits. And this list, as you could see, includes a number of prominent new immigrant destinations, such as Georgia, Indiana, Nevada, Ohio, and Pennsylvania, in addition to traditional immigrant gateways. With the proposed rule considering expanding the range of state benefits in addition to federal that could be considered in the public charge determination, the chilling effects in these states may be particularly far-reaching. And last but not least, finding I'd like to share with you is the benefit use levels by country of birth. If you may recall, 47% of all non-citizens are in benefit-receiving families. This share is much higher among non-citizens from Iraq, the Dominican Republic, and Cuba, on the one hand, and much lower among non-citizens from Korea and India on the other hand. A couple of factors explain these trends: refugee status, household composition, and socioeconomic status. With regard to Iraqis and Cubans, both are refugee origin populations, and as Mark said before, they are generally exempt from benefit restrictions placed on other legal immigrants, and they will be excluded under the new rule. In the case of Mexican immigrants, who are down the middle on the chart, despite high level of employment, these families have lower incomes and are more likely to be in poverty than other immigrants, and hence rely more on public support. By contrast, the higher average education and higher income levels of immigrants from India and Korea make them significantly less likely to use public assistance. Thank you for listening, and now back to Michael for a word about policy implications.
Okay, thank you, Jana. So we've been holding forth here for a while, so I'm going to sum up this very complex qualitative and quantitative report rather quickly and draw a few policy conclusions that can be found in the report. As you've heard really vividly, the impacts of this proposed rule are broad. At least 27 million people live in the United States in a benefits-receiving family with at least one immigrant member. The shares of non-citizens using benefits that would be taken into account in a public charge determination will go from less than 3% under the current policy to at least 47% under the proposed rule. Most, about 2/3 of immigrants receiving benefits, of adult immigrants receiving benefits, work. And as you've heard, the impacts will be felt broadly across states, especially those with high numbers of non-citizens and those with comparatively inclusive social welfare policies. From an immigration perspective, raising income standards from 125 to 250% of poverty, and expanding the set of public benefits that can trigger a public charge determination are likely to significantly alter the composition of future immigration flows. In doing so, they'd represent effectively a backdoor reform of immigration policy, one that will be felt most forcefully by prospective family immigrants, and it's an action that would be taken without congressional votes. Now, in this report, we don't model these these changes in flows, but we expect to do so in future Migration Policy Institute work. In terms of the implications of the rule for immigrant integration and immigrant integration policy, we think that the rule holds powerful implications for individuals in benefit-receiving programs. The reach will likely go beyond those who are targeted, if welfare reform is any guide. It's been thoroughly documented that the loss of nutrition, health, child care, and other supports will lead to poorer health, development, education, and psychological outcomes among immigrant children and their families. That will lead to slower integration and lower levels of self-sufficiency. Further, the studies in the Russell Sage volume that I noted earlier on immigrants and welfare reform documented that welfare has served as a form of settlement assistance by immigrant families. That is to say, they use it in a way that promoted rather than slowed their integration. And of course, it stands to reason that broad disenrollment from public health programs and insurance programs on the part of immigrants and their families could give rise to public health concerns, both for immigrants and for U.S.-born populations alike, and to an increase in uncompensated care that would fall on local hospitals and providers. To continue from this institutional perspective, making the use of a much wider range of not just federal but state-funded benefit programs a consideration in determining public charge could be seen to override state legislative choices that have been made since welfare reform's enactment. These policies not only expanded immigrant eligibility for key benefits, they strongly encouraged their enrollment through outreach campaigns and other affirmative policies. And finally, the new rule could set in motion expensive, complex, and time-consuming new communication efforts on the part of benefit providers who may seek to inform and protect their immigrant clients and the members of their families. So with that, I'll stop. I'll ask Mark Greenberg, the former head of the Administration on Children and Families, if he has any further concluding observations for the panel, and then we'll turn the floor back to Margie McHugh.
Thank you, Michael. Let me just make two last quick points. One is really reiterating something I said before, which is just we are basing all of this analysis on a leaked draft from March. The proposed rule itself could be issued literally any day. When the proposed rule comes out, it could look like the March draft. It could go further. It could perhaps not go as far. So it will be crucial to read it and look at the analyses that are done when it does come out. At the same time, a big part of what you're hearing in our discussion today is drawing from the experience of the 1990s and recognizing how severe those chilling effects were at the time. And it seems very likely that when a proposed rule is out, in many respects even before a proposed rule is out, that service providers and human service agencies and health agencies are, in some instances, already getting questions from clients or potential applicants for services. There are likely to be far more, and it is challenging in this setting to determine what is something simple and straightforward and clear and accurate, but that doesn't at the same time make chilling effects worse. And the part that is absolutely most straightforward right now is there has been no change in the standard. And so, and there will be a process before there is any change in the standard. It will, in my view, be important for people to understand and communicate that, and then for agencies to recognize that while in many instances they may not want to get into complicated issues of immigration law, that their clients will have these questions, that it will be important to develop ways of communicating to help people understand, and where the greatest concerns are misunderstanding and fear, to seek to address that.
Great. All right. Well, so please keep sending in your questions. We have a lot of terrific ones to work off of, and as I said, we will answer any questions we don't get to in this Q&A portion of the webinar just separately on email. I should say that it's a lot for us to already have 3 authors in the room, or the benefit of 3 authors and the diverse areas of expertise they bring with us. But I would guess some of you who are writing in are immigration attorneys with really specific questions also. So one way or other, we'll make sure that we get sort of, to the best of our knowledge, answers back to all of you. But I think I'll stick with some of the broader questions in the beginning. So, Jana, I was thinking that maybe just a few clarification points from you about the nature of the analysis would be good. So I'll just tell you a few that have come in. So some folks are wondering about the undocumented. Are they included in the definition of non-citizen? Who's included? Just, you know, where do the undocumented fit in this? And then also a little bit of confusion about the fact that we're talking about U.S. citizens, and are they actually in the impacts on U.S. citizens, and so the question of why are they included? You know, are we saying that they're going to be impacted, and how would that be? So do you want to maybe clear up both of those to start?
Sure. So the American Community Survey captures the entire U.S. resident population. So it does capture people who are here without documents, so the unauthorized. It's important to note that the unauthorized are, by and large, are ineligible for federal means-tested benefits. So when you look at our non-citizens data as individuals, very few of them will be captured, if at all. However, because the rule will extend the benefits and look at benefits not only received by individuals but also by their family members, and because many unauthorized live in so-called mixed status families where they will have U.S. citizen children and their spouses might be legally present, they will be captured in the analysis. Another group that is included in the non-citizen population are people who are here legally present on temporary visas, such as student visa or work visas, and so they're also ineligible for the most part for the federal means-tested benefits, but they will be captured in the families that receive benefits because they may have dependents that are eligible and do receive these benefits. And then to address the other question, so as I mentioned, the rule itself does not aim to limit the benefit use of U.S. citizens in a direct way. However, some of the U.S. citizens, or U.S. citizens by birth, I should say, will be affected, and if they are wishing to sponsor a foreign-born spouse, they might be affected by the rule and might have difficulties sponsoring a family member for an immigrant visa, or if they're U.S.-born children, and if their parents are afraid of immigration consequences of participation in means-tested benefits, they might withdraw from the programs, and so even though U.S.-born children are not a direct target, they will be affected indirectly, but in very meaningful ways.
Great. So, I think, Mark, maybe just keeping with some of the clarification questions that we've gotten, could you say a little more about, does the proposed rule, or how could the proposed rule apply to family members of refugees, asylees, and people here on special immigrant visas? I think the particular question is, or another version of the question is how would it apply to family reunification applications from those folks? Or does it just not apply at all? But then also, could you say a little more about the totality of circumstances? Is there? It just sounds like a request for just a little more understanding about how that would work.
Sure.
And not just related to refugees and asylum, right?
Yep. Sure. So before responding directly on both, I think the thing to emphasize on all of these specific questions is we're looking at the March draft, that what comes out in the proposed rule may be different from the March draft. And I emphasize that because there were a bunch of differences between the January one and the March one. So really what's going to matter will be what's in the proposed rule that is issued any day. Having said that, around the issue of exemption, the draft does list a set of categories of exemption, and we didn't talk about all of those in our presentation now. For anybody who wants to look at the full list, the March draft was posted by the Washington Post, and so both you can Google it, but also in the report itself, we've got a link to where you can see the language. As to refugees and asylees specifically, it says that refugees at the time of admission and at the time of adjustment of status to lawful permanent residence the draft rule would not apply to them, and similarly for asylees at the time of the grant and at the time of adjustment of status. So that is speaking to the individual itself as to seeking to have another family member come over. I would read this as the other family member. It would depend upon the status by which they were coming in. But again, that's something we will want to look at the proposed rule when it's out. On the totality of circumstances, and I appreciate this one is a little confusing to figure out how the different pieces of the draft rule put together. But the way to think about this, I believe, is that the rule says that you are likely, it's asking, are you likely to become a public charge, that you are if you're likely to receive one or more of the public benefits. It then has a list of the public benefits. It then says, look at the totality of your circumstances, but look at them in order to determine if you're likely to wind up receiving one or more of the benefits. So that it is looking at things like your education and your English language skills and your health and your financial status and your dependents, but all for the purpose of determining, does it make it likely that you or a dependent will receive any of the listed, not any listed, anything that falls within the definition of public benefit.
Great. And then, Michael, a few questions, again, back to specifics. Well, actually, they're crossover sort of specifics about the analysis that you all conducted, but also sort of, you know, what's in and what's out in terms of how people think about it. So, one question is it possible to break the data down further by age, for example, for older adults, because that's a big concern for some folks who are listening in. Also, would we be estimating increases in poverty due to changes in EITC, housing assistance, and the like? And then could you just say a little bit more, since you mentioned potential impacts on child care, could you just clarify, was Head Start taken out of the earlier draft? You know, is child care in? Is school nutrition out or in? You know, just where did we land on those? And also ACA support that folks might receive via ACA, how is that kind of modeled or included?
Okay.
Sorry, that's a bit of a rapid round.
I'll give you a rapid response. Breaking the population down by age, yes, we have broken the population down by age, by children, by working age adults, and by older adults. In terms of have we modeled increases in poverty, We didn't do that for this report, but I would commend people to look at a report issued by Columbia University where Neeraj Kaushal and her compatriots did look at the poverty effects of withdrawal from WIC and child nutrition programs. In terms of Head Start, it was in originally in the January draft, Mark, correct me if I'm wrong, but out of the March draft, and it's up in the air in terms of how far it reaches. In terms of the child care tax credits, that's a bit ambiguous as well. In terms of nutrition programs, they're definitely in they look like they're included now. And in terms of the ACA, how we modeled that was we looked at immigrants who were not receiving the 4 benefit programs, who had insurance and who had incomes under 400% of poverty.
Received private insurance.
Who had private insurance. That was essentially the model that we used. One of the things that's striking, of course, about ACA tax subsidies is that they go up to 400% of poverty. So, and the rule says that if you have an income over 250% of poverty, that's a heavily weighted positive factor. So this could potentially be a conflict, and it creates a gray area for people receiving ACA subsidies whose incomes might be over 250% of poverty, but who also receive subsidies.
Wow, great. And so, Mark, I think I might mush a few questions together for you as well, just so that we can get through a few more while everyone's still on the phone. So, one of the questions is, do we expect the chilling effect to extend to other programs? And for example, there's a concern that if someone has received pro bono or low-cost legal services, is that the sort of thing that might be affected? But then that gets to sort of loops in with another question about that's sort of like a, wait a minute, I thought this only applied looking forward, is it going to apply to the past also? And then thirdly, so how would the government know that people had used benefits that might even count under the determination?
Well, so first, just as to which benefits count, again, under the leaked draft, recognizing that it could change in the proposed rule, under the leaked draft, you're essentially asking, is it means tested, or is it intended to help the individual meet basic living requirements? So it applies to both benefits and services. So if a service is means tested, meaning that eligibility would be dependent upon income or resources, then it would appear that it would count.
And I'm sorry, a number of people have written in about Pell and GI education benefits, so
and
those are in, right?
Well, as to education benefits, what the draft says is it does expressly provide for an exclusion, not counting in-state college tuition and any subsidized or unsubsidized government student loans. But it doesn't go further than that. So for grants that are means tested, it sure looks like they would be counted. They're not expressly referenced here, but it looks like they fall within the definition. Okay, and then I believe there was another part of the question.
The looking forward, looking back?
In the draft, it says that it would be looking prospectively. And as people are thinking about this, it's important to keep in mind this will be a proposed rule, there'll be a comment period, they then take a period of time to review the comments and develop a final rule, and then there would be a final rule. And unless something extraordinary happened, you would probably expect to see the final rule next year, though don't hold us to that because we have no way to know. They are envisioning in the draft that things would be prospective, meaning that they would articulate the new standard in the rule. It would be issued as a final rule. It would be effective then, and what would matter would be benefit receipt after the date of the final rule. Obviously, the qualification on all of this is that things could change, but based upon what we know at this point, that's what it looks like.
Great. And then just as we start to wrap up here, Michael, I think there's an interesting question about, well, given all the research on welfare reform and its chilling effects, is there more that we have learned looking at that research about, for example, how long might we expect the chilling effect to last? What other programs might it impact, and the like? So just is there anything more we can learn looking to the past? And then a few people saying, well, is there anything we can do about this other than simply sending comments when the proposed rule comes out, which maybe a few of you might want to comment on before we close.
On the chilling effects duration, we studied them carefully, and what happened was, following welfare reform, there were quite positive efforts on the part of many states and on the part of the Clinton administration itself to expand eligibility for public benefits and very affirmatively to encourage participation. And so if you look out a few years after welfare reform and after initial steep declines in participation, what you see is recovery in terms of enrollment within the Medicaid program, where the outreach was particularly strong, less so in the food stamp program, where there was less affirmative outreach, but some, and in terms of cash benefit programs, rates stayed low and remained lower than natives, in part because there was such, public policy did not encourage participation in cash benefit programs, but rather encourage participation in work support programs.
And then also, Michael, could you say, there's a question where I think there's maybe a bit of confusion about us focusing on the major benefit programs that we focus on in the report. Could you just say once more why we focused on those particular programs, even though more might, clearly we expect that more might be affected? Two
things. First of all, they're covered in the American Community Survey, which gives us broad spatial and temporal coverage that you don't get in any of the other data sets for other public benefit programs. So we have a larger sample, and we can break things down by space and by state and local governments and by groups more easily than we could. But we also know through the sensitivity analyses that Jana talked about in her presentation that the reach of those 4 programs is really quite broad within the universe of all public benefit users within the immigrant population. It's not complete and it's not universal, but it is rather broad, and so it's a very strong indicator of the extent of chilling effects. Right. You thought that these would be the best indicators of what the chilling effects might be. Yeah. And then, Mark, do you want to just take a whack at the, is the most that folks can do comment on the regulation when it comes out?
So when the rule comes out, there will be a comment period. We would expect it would be 60 days, though it could be longer or shorter. And comments are, in the federal rulemaking process, comments are really important. The agencies have to read the comments, they have to consider them, they have to, when they issue their final rule, they have to explain what they heard from the comments and what, if any, changes they made as a result. So comments are an important part of the process. There are a number of groups, and Michael had referenced some, there are a number of groups that have been putting out reports and doing other kinds of estimations about the potential impacts of the rule, both quantitative and impacts on communities. So there's a lot of helpful things to read out there. I also think that as we talked about some, working with service providers and helping service providers in understanding what to be saying now, what to be saying once is a proposed rule helping them understand this. One of the things, frankly, that we will sometimes hear is that people have a hard time believing that this goes as far as it goes, and so it is helpful to understand precisely what the magnitude of this is and where the potential impacts are. But let me ask Michael, John, anything you want to add?
No,
I just would say in closing, whoops, I'm not able to advance this slide here. So I just would say in closing, first of all, everybody, thanks for sticking with us. Sorry we went a little bit over, but I wanted to also just say that, as is often the case, I don't mean to volunteer Michael and Johnny here, but you heard Michael say it, so I didn't say it first. We have other data lying around from the report, and so a lot of you have written in with really good questions. Please feel free. You can see everyone's emails here, everyone who's been speaking. Please feel free to follow up with them about some of the more specific questions you might have or needs you might have. Obviously, MPI, there's a lot of pieces of the shop here that are keenly interested in this issue, following it very closely, ready to respond. So please stay connected to the work here. And then also, anybody's questions we didn't get to, we will definitely divide them up amongst the people who we think are best positioned to answer them and get back in touch with you. So with that, thank you so much for joining us and for your interest in these issues and in our work on them. Take care. Bye-bye.